Dear partners and colleagues, today Bolotov and Partner and Rodent Partner in Central Asia are glad to welcome you to our second podcast, 3 questions dedicated to intellectual property in Kazakhstan and questions of taxation. Today our speakers will be Yuri Albertovich Bolotov, Managing Partner of Bolotov and Partners, and Michael Quiring, Regional Manager of Rodent Partner in Central Asia.
Thanks, Yuri. Thanks a lot for participating already the second time to our common podcast. If you don't mind, I would suggest that you just introduce a short agenda, what we will discuss today, and that you'll start after that.
Mm-hmm. Thank you for the introduction, for the possibility to speak here. The second podcast will be more specific than the first one was. Now we will talk not just about the general registrations of intellectual property, but specifically about franchise agreements and license agreements, which are to be registered in accordance with the Kazakhstani legislation. Then, certainly the questions related to taxes, as all our podcasts, which are screened in cooperation with Rodent Partner, relate not purely to the intellectual property, but to the IP and taxes. It will be questions about the international treaties, international agreements and taxes within these treaties and these specific already private agreements. And then some questions which will allow to understand how certain expenses can be deducted in course of the entrepreneurial activity of the commercially active bodies in Kazakhstan. So we'll start from franchising, and as a part of franchising, the license agreements. According to the Kazakhstani legislation, franchise agreements must include transfer of the rights to use brand names, company names, and know-how. The other question, the other objects of intellectual property, such as trademarks and patents, are optional. You can transfer the rights to them or not. If only the rights to company names and know-how are transferred, then no registration of franchise agreements is required. But then any registrable objects, when they are transferred from the trademarks and patents holders to the users, from franchisors to franchisee, or from licensors to licensees, then the license agreements or franchise agreements as a whole will have to be registered. Without such registration, such transfers of rights are not valid. Normally, a franchise agreement, especially in the complicated cases, and when the franchise agreement is concluded between the parties located in the different countries, and between the companies which are operating under the different laws, under the different law systems sometimes. Such agreements are thick by pages. There are many pages are included and very complicated from the point of view of combination of technical services, of transfer of the rights to control the business of the licensee or franchisee in Kazakhstan, as it normally happens. And if we put to registration the whole franchise agreement, it takes lots of time to understand all the provisions by the state officers, and we normally suggest to divide the franchise agreement into 2 or more parts. The first one, the franchise agreement itself, where the major points, the substance of business is described, and very short forms of the license agreements to transfer trademark rights and patent rights, which are then forwarded for registration to the patent office. In these cases, these common and very simple forms are registered much easier, much faster, and you don't transfer maybe interesting but not necessary information from the sides of the agreement to the state officers. They will be very happy to read all the business conditions and learn how much every party will earn from the agreement, from the certain types of business. But they do not need this information for the registration purposes. That's why it's better to divide and register such an agreement for trademarks and patent license agreement separately. Only after this registration, the franchisee or licensee will have the right to pay royalties. It is impossible, or rather not allowed, to pay royalties for the period before the date of registration. All such payments will be illegal because it will be payments for transfer, for not existing yet transfer of the rights. This means that the rights are not yet transferred, but franchisee already pays something to the franchisor. It can be considered, and sometimes was considered, as money laundering. Certainly we want to avoid all such unnecessary things, and maybe it's simply to restructure the value of royalties, the sums of transferred monies, for the first period of validity of the franchise or license agreements, which will then cover the predecessor period while this transfer of the rights have not yet been registered. It's just playing with the figures, but it helps a lot. Sub-license agreements must be registered too. And before registration of the sub-license agreement, the license agreement itself must be registered in Kazakhstan. It doesn't matter whether this license agreement or franchise agreement has been concluded somewhere outside Kazakhstan, in any other countries. What matters is the situation in Kazakhstan and the registration of such agreements here. That's probably all what I wanted to say about the registrations of agreements, not just of the trademarks or patents. It's the next step, not establishment of the rights, but rather use of the rights or preparation to use of the rights. And here, taxation is slightly different. Please, Mikhail.
Yeah, Yuri, thanks a lot. I totally agree that from case to case it's really important to divide services, to divide the agreements in several parts, because especially from the taxation point of view, it's important to avoid any queries appearing from time to time with the tax authorities. And maybe I would like to focus in the first step on the international double treaties that are existing between Kazakhstan and other parties, especially between Kazakhstan and Germany. And we see here in our practice, let's say, a lot of problems where some management services have been requalified as franchise agreements. It happened 2 years ago, and that caused a lot of headache for our clients, and I assume for your clients as well. Important to underline that the royalties are clearly defined in the double taxation treaties. So any other definitions which the domestic Kazakh tax authorities try to do are, to be honest, illegal. That's the first step. The second step, it's also important to focus on the fact that the taxation of royalties, it's not a taxation in the sense of taxation, it's only the right in this case of Kazakhstan to withhold some taxes, and then it depends on what is stipulated in the double treaty with Germany, for example. Of course, we have to first of all to focus on the domestic tax rate for the withholding tax. The tax rate is about 15%, but it's clearly stipulated in the double taxation treaty with Germany that only a tax rate of 10% can be applied insofar. Here we have then the third question. Maybe Kazakhstan is allowed to withhold not 10 but 15%. That's the definition of the beneficial owner. The definition of the beneficial owner may be important, as Yuri can confirm it as well, depending with whom such license agreement is concluded. Now we have to clearly define who is the beneficial owner. in our practice we see it often that especially for the trademark an own company has been registered, for example, in Netherlands, but in fact this company is owning only formal, legally the trademarks, but all the money which is receiving in form of royalties will then transfer to another person, for example. In such cases, it's really important to verify, during the process of registration, and to find out who is in fact the beneficial owner, not only on the legal side, not only what is stipulated in the contract, but also to discover it. Why it's important? It's important because the domestic tax authorities can request for additional evidence in order to disclose this information. And if the Kazakhstani company cannot disclose or not able to disclose this information, the tax authorities could also apply at a higher rate for the withholding tax. That is the practice what we have. Fourth topic is, what is the procedure? The procedure is that, of course, for the reduction of the tax rate, it's important to provide a couple of documents, the certificate of residency, etc. There's also clear deadlines stipulated in the domestic Kazakhstani tax code, which makes an administration of royalties not only on the side of registration or maybe prolongation of any rights, but also on the tax side, where the accountants have to monitor it on a regular basis, whether all certificates are available, do we have the apostille on the certificates if it's needed, depends on the country, and such things we as relevant partners are also monitoring. Therefore, it's, let's say, corresponding to what you're doing with that.